It's to the sponsor of this bill, the distinguished gentlelady from Illinois, Ms. Bustos.
Gentlelady is recognized for 4 minutes.
Thank you, Mr. Chairman, and thank you, Madam Speaker. I rise to speak enthusiastically in support of my bill, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. 5 years ago, the Washington Post published a story that shocked me to my core. 69,000 women were suing Sterling Incorporated for sexual harassment, sexual assault, and sexual discrimination. Sterling is the parent company of Kay and Jared Jewelers. And yes, I did say 69,000. I had to double check that over and over. Not 69, not 6,900, 69,000 women. If you didn't do what he wanted with him, you wouldn't get your preferred store or raise. That's what Sonia Douglas, a former employee, testified. A boozy, no spouses allowed sex fest, where attendance was mandatory and women were aggressively pursued, groped, and harassed. That's how meetings at the company were described. You were meat being shopped. That's how a former employee described her workplace. Each story was more disturbing than the story before it. Managers demanding sexual acts in exchange for employee benefits. Company events where women were expected to undress publicly. In one story, a former employee attended an overnight meeting where she woke up with her underwear pushed down to her ankles, a manager raping her. This type of sexual perverseness in the workplace went on for years, and it all stayed secret. And the reason for that secrecy? Because of one single legal clause hidden deep down in these women's employment paperwork. A clause that says, if a claim arises between an employer and an employee, it must go to arbitration. And taking a case like this to court is prohibited. My bill would make it illegal to enforce agreements that mandate third-party arbitration, which is a type of legal dispute resolution that is conducted behind closed doors and often favors the employer. Seems simple, right? Well, that one tiny clause protected a company of abusers and silenced those 69,000 women just at Sterling Incorporated. That's just one single company we're talking about, but the stories go on, and the bad actors aren't just at workplaces. While 60 million, that's 60 million Americans are working under these forced arbitration clauses through their employers, the real number of people impacted by this incredibly common pitfall is huge. Many more millions of Americans have signed away their rights through property leases, rideshare applications, moving companies, nursing homes, grocery deliveries. That terms and conditions box that we've all simply checked off after downloading an app or hiring a service that might just have an arbitration clause hiding in it, ready to strip away your right to go to court if you have been sexually harassed or sexually assaulted and you choose to go to court. While some companies have already eliminated this abusive practice, thank you to them, it's time to do away with these legal traps for good. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act will invalidate any forced arbitration clause in any contract or agreement in the case of sexual assault or harassment. And I'm proud to say that my bill has widespread support among Republicans and Democrats over at the Senate and here in the House. I want to thank those who have helped us get here today. I want to thank Representatives Pramila Jayapal, Morgan Griffith, Ken Buck, David Cicilline, Chairman Nadler, Senators Gillibrand, Lindsey Graham, and Dick Durbin, and our fearless champion on this, Gretchen Carlson. I urge my colleagues to support this, and I look forward to the day when our sexual assault survivors can have their day in court. With that, I yield back.
Gentlelady from Minnesota.
Madam Speaker, I yield 2 minutes to the gentleman from Virginia.
Gentleman's recognized for 2 minutes.
Thank you. I appreciate that, Madam Speaker. I rise in support of H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. I believe pre-dispute arbitration agreements are useful in some circumstances. They can allow common foreseeable disagreements to be resolved quickly and efficiently. But we must acknowledge, in the case of sexual assault and sexual harassment, nobody signs into an employment thinking that they're going to be, oh, I'm going to be sexually harassed, or I'm going to risk sexual abuse. They don't sign up for that. And most of these contracts, Madam Speaker, are what we call adhesion contracts. You have to accept it. And what often happens is there'll be a couple of pages that have all the big items: term of the employment, salary, promotion, vacation, and then they'll incorporate a handbook. The handbook will then have buried in it language that says all disputes must go to mandatory arbitration. And oftentimes the people who are doing the arbitrating aren't lawyers. The rules of evidence aren't applied. The rules of law are not applied. It's just how they feel after they hear everything. This has created a situation that, related to sexual assault and sexual harassment, is unconscionable. It shocks the conscience. And in fairness, it is a violation of public policy, in my opinion, and should be eliminated as a part of a contract. I'm surprised courts haven't already come to that conclusion. But instead of having each court in each of the states and territories make that decision, this act will do it once and for all. And we will have done our jobs to make sure that in these egregious situations, the individual who is making the claim and who has probably been assaulted or has been harassed or has some kind of a valid claim will have an opportunity to go to court or have an opportunity to go to binding arbitration if that's what they choose. But they will have a choice instead of having to go in front of company-picked arbiters who will make a decision for them that will affect the rest of their lives. Now, I will tell you that it is important that we move forward with this bill, and it looks like things are going well, but you never know. But I will also tell you that there's been an allegation that it's retroactive, and that is not accurate as to cases currently pending, but is accurate to contracts currently signed. I yield back.
Gentleman from New York.
Madam Speaker, I now yield 2 minutes to the distinguished gentlelady from Washington, Ms. Jayapal.
Gentlelady is recognized for 2 minutes.
Thank you, Madam Speaker. This is a landmark day. H.R. 4445, the Ending Forced Arbitration for Sexual Harassment and Sexual Assault Act, will ensure that tens of millions of people are no longer silenced in instances where there is sexual harassment and sexual assault. These forced arbitration agreements require that people with disputes against a company use a secretive, one-sided mediation process instead of the judicial system. Sexual assault and sexual harassment survivors with claims against a company are stripped of the right to decide how to pursue accountability for their perpetrator. It is a lose-lose scenario. People are left with little alternative but to sign these agreements, and yet they often face retaliation and backlash when they're pursuing their claims. This bipartisan bill is essential for survivors like Tatiana Spottiswoode, who bravely testified under the protection of a friendly subpoena at a House Judiciary Committee hearing. Tatiana needed that protection because forced arbitration took away all of her rights to speak publicly about the severe harassment that she had endured from her boss and her abuser, former CEO of Affinity, Zia Chisti. At the hearing, Tatiana testified that, quote, "The person who changed my life forever continues to abuse me because forced arbitration gives him the power to do it in secret." Tatiana's freedom to discuss her experiences publicly had real impact. Mr. Chisti was finally fired, and the former Prime Minister of the UK resigned from the advisory board of her abuser's company. Her story and countless others like hers show why this bill is so critical. I am so proud to co-lead this bill with the incredible Representative Sherry Bustos, and I want to thank Representative Bustos and Representative Morgan Griffith and Representative Ken Buck for their leadership as well. No one should have to endure what happened to Tatiana and so many others like her. We have an opportunity in the House of Representatives to set this right for millions of brave survivors. Vote yes to pass H.R.
Gentlelady's time has
4445. I yield back.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield 1 minute and 30 seconds to the distinguished gentleman from New York, Mr. Jeffries.
Gentleman's recognized for 90 seconds.
I thank the distinguished chair of the House Judiciary Committee for yielding for his leadership. I thank my good friend and colleague, Representative Sherry Bustos, for her leadership. The people of America, the women of America, have a right to be free of sexual harassment. The women of America have a right to be free of sexual assault. The women of America have a right to be free of a hostile work environment. They deserve their day in court. The process and practice of forced arbitration undermines these rights without providing an adequate remedy. The American people are being hoodwinked. The American people are being bamboozled. The American people are being led astray by forced arbitration. This practice of forced arbitration is unfair, unjust, unacceptable, unconscionable, and un-American. H.R. 4445 will make it unlawful. I urge strong support for this legislation so that liberty and justice for all can prevail. I yield back.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield 1 minute to the distinguished gentleman from Georgia, Mr. Johnson.
Gentleman's recognized for 1 minute.
I thank the chairman for allowing me to speak, and I want to commend my colleague, Representative Sherry Bustos, for introducing this very important legislation. It's a travesty of justice for a woman to be subjected to sexual harassment and even sexual assault on the job. Oftentimes it takes place in a job setting where there is a culture of sexual harassment and sexual assault. And when these women find, after they have been assaulted, that they are barred from going to court because somehow they have been hoodwinked into a forced arbitration agreement with their employer, they are surprised because at that point they have been assaulted for a second time, because when they go into arbitration, you often find that the deck is stacked against the victim in favor of the perpetrator. And so this legislation gets at that problem by making those kinds of agreements unenforceable. I fully support this legislation. I would ask all of my colleagues to support it. It's good common sense legislation. Justice is all that is asked for. And with that, I yield back.
Gentlelady from Minnesota.
Madam Speaker, I yield 2 minutes to the gentleman from Florida.
Gentleman's recognized for 2 minutes.
Thank you, Madam Speaker. I thank the gentlelady for yielding, and for the 4th consecutive year, I rise as one of the few but faithful Republicans in strong support of this good legislation. Here's the question presented. Should sexual harassers who work for big businesses get to pick their juries in advance? I think that the populist, nationalist, right approach is to believe that the Article III courts that we have set up for any and all function as the proper venue. But for tens of millions of American workers, that courthouse door is locked, it is closed, it is inaccessible. The result is that a system exists for concierge justice, private sector justice. And the evidence before the Judiciary Committee, undeniably, is that big business wins more cases, shuts down more awards, and is able to reduce awards in the arbitration setting, as opposed to the setting that anybody else would be able to enter in a taxpayer-funded court. That is wrong. We have all heard about the fine print in this country. No one reads the fine print. But the fine print shouldn't be a reason that someone is more likely to have to endure sexual harassment in the workplace or more likely to evade consequence as the result of predatory behavior. I want to especially thank the majority for incorporating a number of the minority's views to make this bill stronger and more likely to become law, and I sincerely hope that I'm not here for a fifth year advocating for its passage again. I thank the gentlelady, and I yield back.
The chair will receive a message.
Madam Speaker, messages from the Senate.
Madam Speaker,
Madam Secretary.
I have been directed by the Senate to inform the House that the Senate has agreed to H.R. 1281, an act to name the Department of Veterans Affairs community-based outpatient clinic in Gaylord, Michigan, as the Navy Corpsman Steve Andrews Department of Veterans Affairs Health Care Clinic.
Gentleman from New York.
Madam Speaker, I now yield 3 minutes to a distinguished member of the Judiciary Committee, the distinguished gentlelady from Texas, Ms. Jackson Lee.
Gentlelady is recognized for 3 minutes.
I thank the distinguished chairman for his leadership, and I thank my distinguished friend from Illinois, Congresswoman Bustos, for her constant determination. Wonderful. H.R. 4445 is restoring freedom and justice to women. It is a bipartisan piece of legislation that will not allow any pre-dispute arbitration agreement or pre-dispute joint action waiver to be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to a sexual assault dispute or sexual harassment dispute. I'm glad to hear friends on the other side, as this is a bipartisan bill, acknowledge the fact that this is an absolute injustice, an injustice that befalls a certain segment of the population, and that is women. One of the cases that is most stark is the one of Stefani Bambase, and many witnesses came before us in the Judiciary Committee. Witness after witness after witness gave us horror stories of isolation and fear, and the absolute inability, because of the fine print, to do anything about it. What about Stefani Bambase? Alleged that she worked in a sexually charged and hostile work environment, including being subjected to sexually explicit language from her employer, sexual advances and groping. Let me say that again. Touching in her space from her employer, sexual advances and groping and explicit images. How can you work as a professional or anyone? Think of the levels of work that women are in, from domestic to as high level as scientists and CEOs, but yet they are subjected to this kind of behavior. And according to her petition, she complained to Human Resources to no avail about the harassment, and guess what her relief was? Guess what empathy was shown? Guess what comfort and reforming the system? It was her being fired. That's right, she was fired. How many stories of women that are yet not told who were fired? And so this agreement, of which my colleague has worked on, and we're pleased in the Judiciary Committee to be part of moving this legislation, this will end these arbitration agreements that are snuck into a packet of materials that you signed. It is imperative that we pass it, but more importantly, Madam Speaker, it is imperative that it is passed in the Senate because it's bipartisan, but it's signed by the President and becomes law. I want to thank Ms. Bambase and all of the witnesses who came before us. They sacrificed, they suffered, but yet today, hopefully, will be an announcement, a pronouncement of freedom and justice for women who have struggled with this all of the time. H.R. 4445 is a relief that is long in coming, and it should move away from blind, silent, quiet agreements that no one knows what is. Freedom and justice for women in the workforce today. I yield back.
Gentlelady's time's expired. Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield 2 minutes to another distinguished member of the Judiciary Committee, gentleman from Rhode Island, Mr. Cicilline.
Gentleman's recognized for 2 minutes.
Thank you, Madam Speaker, and I thank the gentleman for yielding. You know, I heard some of my friends on the other side of the aisle say no one wants this legislation. Nothing could be further from the truth. The survivors of sexual assault and harassment want this, and we should listen to them. H.R. 4445 will restore access to justice for victims of sexual assault or harassment who are currently locked out of the court system due to forced arbitration clauses. These clauses are everywhere. They block survivors from making their stories known, having their day in court, and prevents them from holding their abusers accountable. Some of the stories we heard during this hearing were horrific, of the kind of abuse and assaults and demeaning behavior. And those predators knew that they were protected from being held accountable because there were forced arbitration clauses, often accompanied with provisions that kept those proceedings private. And so this legislation, this private system, forces survivors into a process, this forced arbitration, that is not like a court system. There's no discovery, there's no judge or jury, there is no requirement that they follow laws passed by Congress or the states. And when you, as I said, combine that with non-disclosure agreements, it silences the survivors of sexual harassment and assault. Plain and simple. This bill will end it. Predators rely on that silence. As long as their actions are hidden, they're free to act with impunity, and we heard evidence that's in fact what they do over and over and over again. This bill will end that. And I want to thank the sponsor of this legislation, Congresswoman Cheri Bustos, who has made this her life's work since she got to Congress. This bill will help millions of survivors who have had the conduct that they've complained about unaddressed and unanswered and kept quiet. And it will end that practice. We heard testimony about the founder of Invisalign, the CEO of Affinity, who actually started an arbitration and invoked the clause because he knew that would keep the proceedings secret and his abuse would go unaccounted for. This is disgraceful. This should be a unanimous vote. Everyone should want to put an end to this practice. And I urge you to vote yes on H.R. 4445.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield a minute and 30 seconds to another distinguished member of the Judiciary Committee, the distinguished gentlelady from Pennsylvania, Ms. Scanlon.
Gentlelady is recognized for 90 seconds.
Thank you very much, Mr. Chairman. Sexual harassment and violence in the workplace are a corrosive and pervasive threat to the success and dignity of all workers, but particularly women. And forced or mandatory arbitration clauses in employment contracts have played an important role in thwarting efforts to hold accountable the predators who engage in such conduct and the companies that allow it to continue. The widespread use of these clauses in employment contracts forces many Americans to agree to a form of dispute resolution that silences victims of sexual harassment and assault and allows their harassers and employers to escape accountability. These arbitration proceedings overwhelmingly benefit the employer, which drafts the non-negotiable clauses dictating the venue, the terms of mediation, even the arbitrators themselves, as well as creating a perverse incentive for the allegedly neutral arbitrators to rule in favor of employers, lest they not be hired again. In addition to denying survivors a public forum to expose sexual abuse, which can deter future misconduct, these arbitration clauses also preclude class actions, which is often the only way that employees can afford to bring successful claims. H.R. 4445 would ban the use of forced arbitration in employment contracts in cases of sexual assault and harassment. In addition to protecting survivors of such harassment, that is just good public policy. With that, I yield back.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield a minute and 30 seconds to another member of the Judiciary Committee, the distinguished gentleman from Maryland, Mr. Raskin.
Gentleman's recognized for 90 seconds.
Madam Speaker, thank you, and thank you, Mr. Chairman, for yielding. I want to salute our colleague, Congresswoman Bustos, for introducing what will certainly be the most important piece of pro-labor legislation to pass out of the 117th Congress. Our Constitution guarantees our people the right to a jury trial, but forced arbitration in the workplace brutally cheats victims of sexual harassment and assault in the workplace out of their right to a trial before a jury of their peers. And by stripping women of this right, forced arbitration is creating corporate cultures of pervasive and severe sexual harassment all across the country, like the one Eliza Dushko faced in Hollywood, where she got fired for objecting to constantly or to constant sexually degrading and humiliating treatment in the workplace. We heard testimony from women sexually harassed and raped by repeat offenders who've been made proud and contemptuous because their conduct is consistently buried and hidden in regimes of coerced, closed-door arbitration. We have created monsters out of repeat offender sexual harassers across the country. Let's throw the doors open and let's let the sun shine in. Let's restore the full constitutional rights of women in the workplace. Let's pass this legislation. I yield back, Mr. Chairman.
Gentlelady from Minnesota.
Madam Speaker, I yield 3 minutes to the gentleman from Colorado.
Gentleman's recognized for 3 minutes.
I thank the gentlelady from Minnesota. Madam Speaker, I rise in support of H.R. 4445. This is the way the legislative process should work. This started with a victim of sexual harassment, Gretchen Carlson, who stepped forward and brought a cancer within an organization to light and did it in a courageous manner. Then my colleague, Congresswoman Cheri Bustos, took on this cause and wrote a good piece of legislation. But what she did was even more important. She was open to suggestions and often adopted suggestions to make this the very best legislation that it could be. And my friends, Congressman Matt Gaetz and Morgan Griffith, worked alongside her and worked on our side of the aisle to make folks aware of the need for this legislation. I urge my colleagues to support H.R. 4445 because, one, it empowers rape victims to make a choice between arbitration and going to court. It also makes sure that sexual predators are held accountable. And finally, it puts corporations on notice that if they don't clean up their act, they're going to have a big problem. There's no more sweeping an issue like this under the carpet. This is something that corporations are going to take seriously, and they're going to change their conduct as a result of a possible change to their bottom line. This bill gives members a choice to support rape victims or rapists. I choose to support the rape victims, the survivors of a terrible ordeal, and I urge my colleagues to do the same. I yield back.
Gentleman from New York.
Madam Speaker, I now yield a minute and 30 seconds to another member of the Judiciary Committee, the distinguished gentlelady from Texas, Ms. Garcia.
Gentlelady is recognized for 90 seconds.
Thank you, Madam Speaker, and thank you, Chairman Nadler, and thank you to the sponsor of this bill, Cheri Bustos, for her hard work. I rise today to express my strong support for this bill, H.R. 445. As a former judge, I have a very deeply held belief that everybody should have their day in court. It's a simple principle. Everybody should have their day in court. That is the essence of justice for all in our country. Every time we say the pledge and we end with justice for all, we've got to demonstrate that we mean it, that survivors of sexual harassment and discrimination in the workplace deserve to have their voices heard. By ending forced arbitration in lawsuits involving sexual assault or sexual harassment claims, we ensure survivors are given a real choice of whether to go to court or to arbitrate their claim. Abusers will no longer be able to misuse arbitration law with dubious agreements and fine print clauses to hide their violence and silence their victims. I am proud that we are taking firm bipartisan action to ensure justice for sexual harassment and sexual assault victims. I'm proud that we're making sure that when little kids across America say justice for all, that it truly means for all. I urge my colleagues to vote yes on H.R. 445, and I yield back the remainder of my time.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield a minute and 30 seconds To another member of the Judiciary Committee, the distinguished gentlelady from North Carolina, Ms. Ross.
Gentlelady is recognized for 90 seconds.
Thank you, Madam Speaker, and thank you very much, Mr. Chairman, and especially thank you to our colleague Sherry Bustos for bringing this important legislation to us. I rise today in support of H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. In 2017, our country experienced a dramatic and needed shift. Women in a variety of industries responded to news of allegations against powerful men with the hashtag #MeToo, banding together in solidarity to expose predatory behavior that has been overlooked and excused for generations. But some women are still not able to speak out against their abusers because forced arbitration agreements prevent them from doing so. Last year, the House Judiciary Committee heard testimony from women from a variety of backgrounds and political parties who have suffered the dual injustices of sexual abuse and forced silence through arbitration. Their stories illuminate how forced arbitration agreements are too often used to protect assailants and their companies at the expense of working women. It's past time for Congress to enable these women to reclaim their voices and take control over their own lives. I urge my colleagues to support H.R. 4445. Thank you, and I yield back.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, I now yield 1 minute and 30 seconds to the distinguished gentlelady from Connecticut, Ms. DeLauro.
Gentlelady is recognized for 90 seconds.
The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act is bipartisan. It's legislation that provides survivors with the resources they need to seek the justice that they deserve and empower them by giving them a choice to go to court instead of being forced into arbitration. Survivors like Susan Fowler, who in 2015 was working for Uber when her manager started sexually harassing her. She immediately reported this to Human Resources, but when she did, her manager threatened to fire her. And since Uber employees are forced to sign arbitration agreements when they are hired, preventing them from bringing sexual harassment claims to court. Susan was forced into a confidential dispute forum without the right to appeal. 3 years later, Susan had had enough, and she spoke out, writing in an op-ed for the New York Times, and I quote, "From the systemic culture of sexual harassment and discrimination at Uber to the ubiquitous stories of women taken advantage of in industries ranging from professional football to restaurants, we have seen one company after another publicly outed and shamed for illegal treatment of employees." And Susan rightly asks, and I quote, "The question is no longer whether mistreatment actually occurs, but what can we do to ensure that it never happens again?" The answer is simple. We can pass this bipartisan legislation, end the practice of forced arbitration. And with that, I urge my colleagues to vote in favor of this bill. Thank you, and I yield back.
Gentlelady from Minnesota.
Madam Speaker, I reserve.
Gentleman from New York.
Madam Speaker, we have no further speakers. We're prepared to close.
Gentlelady from Minnesota.
Thank you, Madam Speaker. I yield 4 minutes.